UCLA, where I'm affiliated with the UCLA Health Law and Policy Program. The directors of this innovative program are Diana Winters, who is the director of the program, and Lindsay Wiley, who is the faculty director of this program. Professor Wiley is giving a talk at another university today, but shares her enthusiasm for today's program and her welcome to our speaker and all attendees. Fortunately, Diana Winters is available and is attending with us. I'm very grateful to both of the directors of this program for their sponsorship, their enthusiasm for this topic. News about future speakers in this series is available now on the UCLA Health Law and Policy Program webpage, and the recording of today's event will also be posted there. I would like to acknowledge also the Psychedelic Advocacy Network, which was co-founded by Pamela Wood and Henry Passett. The Psychedelic Advocacy Network maintains a supportive presence in 9 cities where the network inspires, educates, and builds community among those who share an interest in psychedelics. Thanks to the network, many learned of this event and are joining us today. In addition to our UCLA Law Events team, AV and IT departments, I would like to thank Mililani Drybus, a faculty support assistant, whom you can see participating now to assist us. She's with us now and will be helping to ensure smooth sailing on the virtual side of things. Kelly Conan, whom you also see, is in room 2357 here at the law school, assisting members of the community choosing to attend the event while at the law school. So my thanks to all of these people whose support is essential to bring about this valuable experience with Professor Marks. Professor Marks, thank you so much for joining us today. You are our inaugural speaker in this series, and I was so delighted when you agreed to join us for this event today, despite a really busy schedule and a looming book deadline. I have to say, I think you are remarkably courageous to be publishing a book at this time about emerging trends in state and federal law regarding psychedelics, because as soon as it's published, it will need to be updated. It is just such a fast-moving field. So congratulations to you. And also congratulations to you and your group at Harvard Law School for the recent gift. I believe it was a $16 million gift to support work in this area. I'd like to spend just a few minutes introducing everyone to you, and then we'll turn it over to you for your presentation. We will have a Q&A option open during the webinar so that people can start putting in questions, but the format will be giving you some time to get into your subject matter and then take questions as you choose. Okay, so I would like to start first with some of the background that brings you to us. So you graduated with a you graduated with a bachelor's in biology in the year 2000, then graduated from Tufts University School of Medicine with a Doctor of Medicine in 2011, and then Professor Marks graduated from Vanderbilt Law School in May of 2015, earning his Juris Doctor while he was there. So comes to the subject matter with the perspective of both the medical degree and a legal degree. He is an extraordinarily prolific writer for someone of his years, and so has published in law reviews, scientific journals, and a variety of more popular press kinds of avenues as well. He has forthcoming articles on decriminalizing psychedelics in Fordham Law Review. He has recent publications in microdosing under state and federal law, patents on psychedelics, the next legal battlefield of drug development. And the book that I mentioned previously is the Psychedelic Law and Policy, which is forthcoming from Yale University Press. So thank you so much for joining us today. We look forward to hearing your thoughts about these emerging trends in state and federal law.
Thank you so much for having me. It's really a pleasure to be with you, and thanks for that very kind introduction. You asked me to say a little bit about how I became interested in psychedelics, and so I think I'll start with that. And that really goes back to my time in medical school at Tufts, where I was very interested in psychiatry, among other topics like neuroscience. And when I did my psychiatry rotation, which is a 6-week rotation in a locked psychiatry ward, I was really struck by the current state of psychiatry. It felt to me as though we had far fewer options available for many people than I anticipated. And I took that concern, that observation with me as I continued on into law school, where I then learned that the laws regarding psychedelics were not necessarily well grounded in science, and that psychedelics had some fairly promising potential to help people that might not otherwise be helped by existing therapies. And I thought that was really upsetting and concerning, that the law was potentially serving as a barrier to development of these new treatments for people for a variety of mental health conditions, and not only mental health conditions, but medical conditions as well. And I'll talk more about that. But that was the origin of my interest. And when I was in medical school at Vanderbilt, there was a course on marijuana law taught by Professor Robert Michos, who was one of the pioneers of that field, and literally wrote the book, the big case book on marijuana law. But at the time, there was nothing like a course about psychedelics. Psychedelics were still very heavily stigmatized. This was in 2015 when I graduated from Vanderbilt. And I wrote a paper about psychedelics for a bioethics course there in 2015. So that was sort of my first introduction to really thinking deeply about psychedelics as an academic subject. So that's just a little bit of introduction to how I got interested in the topic. But today I want to talk about the psychedelic legal renaissance. You may have heard of the psychedelic renaissance. I'll give you an overview of what that is. But I want to focus in on the legal reforms that are really making that renaissance possible. So what is the psychedelic renaissance, or more importantly, what are psychedelics? That's probably a good place to start. So psychedelics are a pretty broad category of substances that have the potential to significantly influence people's perception, how they perceive themselves and the world around them. And so they influence thought and perception. And they include naturally occurring substances that are produced by plants, fungi, and even animals around the world. And they've been used by indigenous communities throughout the world for hundreds of years, if not thousands of years. Some of those communities are Native American communities in North America, both in the United States and parts of Mexico, who utilize the peyote cactus in healing and spiritual ceremonies. Peyote cactus contains the psychedelic mescaline. There are people in Central West Africa, in countries like Gabon and Equatorial Guinea, who utilize iboga, which is a shrub that produces a psychedelic called ibogaine. And there are people in mountainous regions of Mexico who have been using psilocybin-producing fungi for hundreds of years in their religious and healing ceremonies. And many of those people are descendants of the Aztec who utilized both peyote and psilocybin-producing mushrooms. Other psychedelics are synthetic. So they were produced for the first time by scientists in the early 20th century. And these are substances like LSD and MDMA. MDMA, I should highlight, as a substance that some people don't consider to be a psychedelic. They might call it an empathogen or an entactogen, but it has psychedelic-like qualities. So it may not be a classic psychedelic, but people often lump it in with psychedelics. Now, even though the history of psychedelic use goes back thousands of years by indigenous communities, the so-called discovery of psychedelics by Western scientists didn't really occur until the early to mid 20th century. And in the mid 20th century, there were scientists that traveled to these places like Mexico to experience these substances, and they brought them back to the United States. And R. Gordon Wasson was one of the famous individuals that traveled to Oaxaca, Mexico, and brought psilocybin mushrooms back. And there was a very influential article published in Time magazine about his exploits, and that kind of sparked the scientific interest in psychedelics that exploded in the 1950s and 60s. There were quite literally hundreds of articles written about the therapeutic applications of psychedelics like LSD and psilocybin for things like treating various types of addictions. But of course, as you likely know, psychedelics became associated with the countercultural movement and opposition to the Vietnam War. And there was mounting political and legal opposition to their use. They really were not regulated prior to the mid 1960s. Due to that backlash, there was a bill signed by President Johnson, the Drug Abuse Control Amendments of 1965, which went into effect in 1966. And this bill dealt with hallucinogens, an older term for psychedelics, but it lumped them in with other substances like barbiturates, so depressants, and stimulants like amphetamines. In 1966, there were 2 states that banned LSD. California was one of them, Nevada another. And then those drug abuse amendments of 1965, they went into effect the following year and also effectively banned psychedelics or the hallucinogens. And then 5 years later, in 1970, the Nixon administration proposed, and Nixon later signed, the Controlled Substances Act of 1970. That created these 5 schedules of drugs that many people are familiar with today. And psychedelics were placed into Schedule 1, the most heavily restricted category, which is believed, the substances in that category believed to have no currently accepted medical use and a high potential for abuse. 3 years after the Controlled Substances Act was enacted in 1970, Nixon formed the Drug Enforcement Administration, or DEA, in 1973. And since then, the DEA has been tasked with scheduling and rescheduling substances with some input from the Food and Drug Administration, or FDA. So the effect of that, of all these legal changes in the 60s and 70s, was that all of that enthusiasm for scientific research on psychedelics of the 50s and 60s effectively slowed. It almost came to a complete stop. There was some minimal research on existing stores of LSD, for example, that continued into the late 70s. But after that, psychedelic research was effectively dormant. There was a significant stigma against the substances. People were hesitant to mention them publicly. Scientists were hesitant to study them. And so it's this period of dormancy that allows us to talk about the psychedelic renaissance, which I think of as a resurgence of interest in studying and commercializing these substances. And that really dates back to the early 1990s. There was a researcher at the University of New Mexico named Rick Strassman who obtained permission from the FDA and DEA to study a psychedelic called DMT in healthy volunteers. And then in the early 2000s, there was additional research, largely at Johns Hopkins University. And there was some very, very impressive data that came out of the studies there on utilizing psilocybin in people with serious life-threatening conditions like cancer. who were suddenly facing their own mortality and experiencing a lot of anxiety and depression associated with that. And there were some impressive studies out of Johns Hopkins that showed that psilocybin could help alleviate those symptoms, sometimes for extended periods, up to 6 or 12 months after the administration of the substance. So since then, early 1990s, early 2000s, there really has been a trickle of psychedelic research that has grown into more of a steady stream. There were some watershed moments that really helped to shed some of the stigma that lingered. For example, around 2017, 2018, the author Michael Pollan published some very influential work, including his article in the New Yorker called The Trip Treatment and his book, How to Change Your Mind. Those really should be considered watershed moments in the psychedelic renaissance that really started to change people's attitudes in conjunction with the research that he talks about in those works. So that brings me up to the psychedelic legal renaissance. That's sort of the scientific part of the psychedelic renaissance. And we start to see the psychedelic legal renaissance coming onto the stage in 2019. I published an article last year in the journal Neuropharmacology called The Varieties of Psychedelic Law, and I attempted to map the landscape of the different approaches to psychedelic legal reform that we're seeing across the country. And you mentioned during the introduction that my book is a bit daring because it's chronicling these legal changes and could be outdated fairly quickly. And so by providing sort of a typology of the different types of laws, that's one way I'm attempting to combat that potential expiration date of anything I write in the book, by really describing different categories of law instead of focusing solely on specific laws. But I want to point to some specific laws here, real landmark moments in this psychedelic legal renaissance. But I'll do that by talking about the different categories. So I mentioned 5 different categories or varieties of psychedelic law. They are decriminalization, supported adult use, medical use, clinical research, and policy analysis. And there are other categories. Retail sales would be one of them, or dispensary sales. But these 5 are the ones that we currently see in the US. I'll start with decriminalization. That's the first category. It's also the first category that we saw in the United States. And I describe that as the elimination or reduction of criminal penalties associated with psychedelics or various psychedelic related activities, or decreased enforcement of those penalties. So you're either getting rid of the criminal penalties or you're just not enforcing them. And the first decriminalization of a psychedelic occurred in Denver in 2019 through a voters ballot initiative called Initiative 301. That created an ordinance, a city ordinance. It said that the city could not spend any resources to impose criminal penalties for the personal use and possession of psilocybin mushrooms by people 21 years of age or older. So this is one type of decriminalization. It was an ordinance in this case, so it had legally binding effect. But there's a whole spectrum of approaches to decriminalization. I wouldn't think of it as one thing. It can vary in a number of ways. One way is in the range of substances that are included. So in that sense, Denver's initiative and ordinance are fairly narrow because they only include psilocybin, and subsequent reforms have included a broader variety of psychedelics. And then the other way they vary is in the variety of activities that are decriminalized. So again, Denver's decriminalization was fairly narrow. It decriminalized possession and use. And we've seen in subsequent reforms that other activities have been included, and I'll talk about those in a moment. So shortly after Denver decriminalized mushrooms in 2019, other US cities followed suit. Oakland and Santa Cruz, California were some of the fastest. And as far as I know, no other city, and there are I think about 20 now across the US that have done this. I don't believe any city other than Denver has passed an ordinance. They've all passed resolutions, which are not legally binding. It's more of a statement of policy of the city council or the legislature in the city. And so it's important to distinguish between an ordinance, which is legally binding. The city absolutely cannot spend resources on enforcing criminal penalties associated with psychedelics, and a resolution, which is merely a statement of policy. It has undoubtedly a lot of symbolic value. These decriminalization efforts in cities like Ann Arbor, Michigan, Seattle, Washington, Somerville and Cambridge, Massachusetts, and most recently, Eureka, California, and Portland, Maine, they've generated a lot of press attention. They've shifted attitudes across the country. So they have a lot of symbolic value, and they likely do have some real functional effects on policing, even though they are not, technically legally binding. So that's decriminalization at the city and county local level. There has also been decriminalization at the state level. And the first state to decriminalize psychedelics was Oregon. In November 2020, during the presidential election, Oregon voters approved ballot initiative or ballot measure 110, which decriminalized possession of personal use amounts, so small amounts of psychedelics, but not only psychedelics, other drugs like cocaine and heroin. And this measure was modeled after Portugal's decriminalization of drugs in 2001, where Portugal attempted to take more of a public health approach to drug use generally, as opposed to a law enforcement criminalization approach. And so Oregon's Measure 110 was modeled on that. And what it did was it eliminated criminal penalties, which had already been reduced from a felony to a misdemeanor in Oregon a few years back. But it got rid of the misdemeanor, replaced them with a civil penalty, a $100 fine. And so people who were found to be in possession of the personal use amounts, they would either pay the fine or they could avoid paying the fine by calling a hotline that provides people with access to support services. And Measure 110 siphoned hundreds of millions of dollars from Oregon's cannabis industry tax revenue to these support services. And so, at least in theory, people could call this hotline. They could potentially access some of these services funded with the cannabis tax money. And just like Oregon was inspired by Portugal, Oregon's Measure 110 inspired other places like British Columbia, Canada, to enact psychedelic decriminalization. But there has been a significant pushback in the last couple years, a backlash against Measure 110 in Oregon. There are people there that are calling for its repeal. They're saying that it has failed. They say that it has not actually significantly increased the number of people enrolling in support services. I question whether that really was the primary purpose of Measure 110. There are other reasons that one might want to take a public health approach to drug use instead of a law enforcement approach, including harm reduction and just sort of social justice reasons, not wanting to criminalize drug use. So not only is Measure 110 not necessarily a failure, as some people are claiming, it's also arguably far too early to really draw too many conclusions about it. And there were some significant delays in getting those hundreds of millions of dollars routed to these support services. So that may have also impacted the outcomes there. But it's a very controversial bill that was the topic, a hot topic in the recent gubernatorial election in Oregon. So that brings me to the next category or variety of psychedelic law, which is supported adult use. And this would be a good place to distinguish between decriminalization and legalization. These are terms that are often used interchangeably by reporters, for example. I think it can be very misleading or confusing. Things can get confusing very quickly. So I and many other people try to use these terms consistently. Decriminalization, as I said, you're eliminating criminal penalties or not enforcing them. Legalization is typically used to refer to creating a system of regulation. So setting up rules for the manufacturing, transport, distribution, dispensing of psychedelics. And so that leads me into supported adult use, the second category of law. And here I like to make an analogy to adult use cannabis, which some refer to as recreational cannabis sales that are available in many states, including California. And under adult use or recreational use, people can go to a dispensary, they can buy cannabis for any reason. They don't need a medical diagnosis, they don't need a prescription. They buy it, they take it out of the store, they use it for whatever reason they want. It could be for spiritual enlightenment, creativity, or just to see what it's like, right? Supported adult use of psychedelics is just like that, except for this supported piece. People are supported or supervised by a trained individual, often referred to as a facilitator, who educates the client. They're called clients in Oregon. They're called participants in Colorado. But the facilitator educates the client, obtains informed consent from them for what are called psilocybin services. Those services are rendered at a psilocybin service center, and the facilitator might have to be there for 5 or 6 hours, depending on the dose of psilocybin administered and how strongly and for how long they affect the client. So that is supported adult use. And that was created in Oregon, which is, again, the first state to not only to decriminalize, but also to implement supported adult use. Alongside Measure 110, Oregon voters approved Measure 109, or the Oregon Psilocybin Services Act. That did a few things. It triggered a 2-year development period. And in the spring of 2021, the governor of Oregon appointed members to a psilocybin advisory board. And that board made recommendations to the Oregon Health Authority, the public health agency in Oregon, about rules for regulating this new psilocybin industry. I was fortunate to serve on the psilocybin advisory board, where I chaired the licensing committee. And this 2-year rulemaking period ended last December when the Oregon Health Authority published final rules about these psilocybin services. And then on January 2nd, the authority started accepting license applications from aspiring businesses. It started issuing licenses in the late spring of this year, and in the summer, the industry opened for business. So we now have psilocybin service centers serving clients throughout Oregon. And actually just this week on Wednesday, the Oregon Health Authority will hear public comments, I believe Wednesday through Friday, about its latest update to the psilocybin rules. So there are some changes that are some small tweaks and some bigger changes, for example, involving data collection, that the health authority has put into proposed rules, and now it's seeking public feedback. So if you're interested in that, just Google Oregon psilocybin services, and you can actually watch those public comment sessions or participate in them. The second state to implement a system for supported adult use of psychedelics was Colorado. And last November, voters there approved Proposition 122, or the Natural Medicine Health Act. There are frequent comparisons made between Oregon's Measure 109 and Proposition 122 in Colorado. They're often lumped in together, but there are really some very important key differences that I want to talk a little bit about. The first key difference is that in Colorado, So Colorado is a couple years behind Oregon. The same type of advisory board is set up. The Natural Medicine Advisory Board was established this spring, and so they've been meeting for 6 or 7 months now, starting to talk about rules. But one of the key differences is that though in Colorado they'll start out with psilocybin, the Natural Medicine Health Act creates the possibility to include other substances, other psychedelics like ibogaine, mescaline, dimethyltryptamine. Those could be added. Ibogaine could be added in 2025 when the industry opens for business, if regulators suggest and approve that. And the other substances, mescaline and dimethyltryptamine, could be added no sooner than 2026. So that's a key difference. Another difference is Oregon has some very interesting boundaries that are established in the rules between the psilocybin services on one hand and conventional healthcare on the other. So there's sort of a clear boundaries between those two things. What that means is that psilocybin facilitators in Oregon, they are not allowed to diagnose or treat medical conditions. They can't make medical claims. They can't operate within a licensed healthcare facility. And if a facilitator is also a licensed healthcare professional, like a nurse, physician, physician's assistant, when they're acting as a psilocybin facilitator, they cannot exercise any of the privileges of their healthcare license. So they kind of have to take off the healthcare professional hat and only wear the psilocybin facilitator hat. Colorado doesn't have any of these limitations. And so it's very much blurring the lines between what they call natural medicine services in Colorado, rather than psilocybin services, and conventional healthcare. It's very likely that you will see healthcare providers or psychedelic facilitators diagnosing and treating medical conditions. They'll likely make medical claims. And so really Colorado's law is sort of a hybrid of supported adult use and the third category of psychedelic law, which is medical use. I'll talk about that in just a moment. But before I do, I want to mention another key difference between Oregon and Colorado's psychedelic law. Colorado's included decriminalization for personal use in the Natural Medicine Health Act, and it is far broader than Measure 110. So Measure 110, remember, people can have a personal use amounts, and the only penalty is to pay the $100 fine, which they can avoid. In Colorado, on the personal use side of the Natural Medicine Health Act, there were 5 psychedelics that are decriminalized, not only for possession, but for cultivation, possession, sharing, even sharing or gifting without remuneration to other people. So the activities that are decriminalized are much broader than under Measure 110 in Oregon. The substances included are much broader, and there's no penalty. So you're not subject to that $100 fine. There's just no penalty at all, at least under state law. And of course, I should emphasize that under all of these programs, whether it's local decriminalization or state level supported adult use or medical use, all of these programs are federally illegal because of the Schedule 1 status of psychedelics. So let me talk then about medical use, the third category. I think of that as being just what it sounds like. It's the medical use of psychedelics, the use of psychedelics in the treatment of health conditions. And that could be either within the conventional healthcare system, utilizing FDA-approved psychedelics, substances like MDMA or psilocybin, which could be FDA-approved in the next few years. But it could also refer to state-regulated psychedelics being used for medical purposes, like in Colorado. And again, Colorado's program won't open for business until at least 2025. And when that happens, these substances that are administered through that program will remain federally illegal. Even if the FDA does approve those same substances for therapeutic use and marketing, those would be synthetic substances in most cases, most likely, the FDA approved versions. The naturally occurring varieties or the substances extracted from the plants that are decriminalized in Colorado, those would remain federally illegal and in Schedule 1 despite the FDA approval of the same substance. The approval and subsequent rescheduling, moving the substance from Schedule 1 to a less heavily restricted category like Schedule 2 or Schedule 3 will only occur for the FDA approved version. And we know this because this is, we can turn to the history of cannabis or marijuana, or more specifically THC, the active ingredient in marijuana, or one of them being rescheduled from Schedule 1. At one point, THC occupied 3 different schedules on the controlled substances list. So in Schedule 1, there was naturally occurring THC, and then in Schedule 2, an FDA-approved version like Marinol or Syndros. And so it's a very odd, strange sort of scheduling process that we have, that we can end up with these strange results where the same substance is in many different schedules. So where are we, just setting Colorado aside for a moment, where are we when it comes to FDA-approved psychedelics? The evidence, the scientific evidence for therapeutic use is strongest for the use of MDMA, which colloquially is called ecstasy, of course, use of MDMA for treating post-traumatic stress disorder, and the use of psilocybin for treating treatment-resistant depression. Those are the substances and indications that are farthest along in the FDA approval pipeline. There's an organization called the Multidisciplinary Association for Psychedelic Studies, or MAPS, and it recently concluded a second phase 3 clinical trial. Phase 3 is the last stage before FDA approval of MDMA. And so many expect that the FDA could approve MDMA for treating PTSD as early as next year. And then another company called Compass Pathways, or Compass Pathfinder Limited, recently commenced phase 3 clinical trials of psilocybin for treating treatment-resistant depression, and many people expect that psilocybin could earn FDA approval as early as 2027. But in the meantime, you have facilitators providing psilocybin in Oregon at service centers, again, Schedule 1, federally illegal, and you will have psilocybin being dispensed in Colorado from 2025 onward. So what I want to do now is just briefly talk about the other 2 categories of psychedelic law, and then I want to talk about some of the controversies in this space, so some of the criticisms and concerns about some of the programs that I've discussed, and then I would love to have more of a discussion with you. So the 4th category of psychedelic law is clinical research. And this is a more conservative approach to psychedelic legal reform than the approaches taken in Oregon or Colorado. Really, it just amounts to utilizing state funds to run clinical trials involving psychedelics. And Texas was the first state to do this. A few others have since followed suit, including Washington State, where a bill was sponsored initially as a supported adult use bill. It was modeled after Oregon's. It had some additions to it. I was involved in making some of those additions, but ultimately as that went through the legislature, this was not a ballot initiative like in Oregon and Colorado. As it made its way through committees within the legislature, it got whittled down and ultimately became a clinical research bill like Texas. And then Connecticut also has a clinical research bill, and there will be research commencing very soon, if it hasn't already, at Yale University involving psilocybin and likely MDMA. So that's state-funded psychedelic research. The final variety is policy analysis. This is an even more conservative approach to legal reform. That is just establishing a task force or a work group to study the issue. So just creating a committee to talk about potential further legislation. So let me talk a little bit about some of the potential concerns and criticisms of these legal reforms. Oregon opened for business this summer. What are some of the concerns associated with Oregon's Measure 109 or psilocybin services program? One big concern has been the cost. And by that, I mean both the expense to clients as well as the cost to the state and to taxpayers. The cost of opening not only clients, but also business operators. So the cost of opening a business like a psilocybin service center is very high. And that is due in part to the licensing fees that the Oregon Health Authority charges these businesses. So in order to open a service center, for example, one has to pay an annual license fee of $10,000. And if one wants to become a psilocybin facilitator, they have to pay a licensing fee of $2,000. And I like to compare that to the fees that a doctor or a lawyer might pay every year. So I'm a member of the California Bar. I think I pay about $400 to $450 a year to maintain my bar license, whereas a psilocybin facilitator has to pay $2,000. So it's quite a significant difference. That's one barrier to opening a business, and those costs are passed on to the client. The cost of a psilocybin services experience. So I should talk about what that consists of. In Oregon, psilocybin services, there's 3 stages. There's a preparatory session where the facilitator collects informed consent and educates the client. Then there's an administration session where psilocybin is dispensed. And then there's an optional integration session where the facilitator would talk to the client about the experience, and the client might try to integrate that into their existing life. That must be offered, but need not be pursued by the client in Oregon. It's required in Colorado. It will be required. That round that I just described, those 3 phases, the estimated cost in Oregon to clients ranges from about $1,500 to $3,000. So it's quite expensive. And one of the reasons that the licensing fees for the businesses are so high is that the system created by Measure 109 was supposed to be self-sustaining, self-sufficient. It was the state's administration of the program was supposed to be supported by these licensing fees. But the problem is, it's not just that it's not just paying the license fee that's expensive for these businesses. There are also some problems related to Section 280E of the Internal Revenue, the IRS code, the tax code, where a business cannot deduct expenses related to a Schedule I controlled substance. So this is a problem that cannabis businesses have faced for many years. It raises the cost of doing business, it raises the overhead, and then you add to that the financial risk of starting a business in this industry and the licensing fees, and you can see why a lot of businesses might be dissuaded from entering the market in the first place, and some companies have entered the marketplace and gone out of business. So the effect of that is that there's not enough revenue from the licensing fees to pay for the state to administer the program. Last year, in the past year or so, the Oregon Health Authority collected about $300,000 in license fees. They really need about 10 times that. They had to go to the state early this year, and ask for Well, they asked for about $6 million to run the program for 2 years, and they ended up getting a little over $3 million. So it's costing the state and taxpayers a lot more than promised and anticipated, and it may not be as accessible to clients as many had hoped. So that's one of the problems, the expense. I think the same issue will be, regulators will face the same problems and business owners will face the same problems in Colorado, because it really does have a very similar design despite some of the differences that I pointed out. And one thing that regulators are looking at in both Oregon and Colorado as a means of making up for this high cost of accessing these services is insurance coverage. Is there any kind of insurance coverage that could be obtained for clients or participants, as they're called in Colorado? I'm not very optimistic about that, but in Colorado, that Natural Medicine Advisory Board spends a lot of time talking about ways to entice insurance companies to provide coverage for these services. There's even talk of utilizing the state's Medicaid program to pay for not the substances themselves, but some of the services offered in conjunction with the substances. And I'm really doubtful that insurance coverage will be feasible for these substances that, again, are Schedule I controlled substances. We're not talking about the FDA approved versions. I'll just mention a few other issues that come up when people are talking about these kinds of programs. One of them is, who is qualified to monitor clients? Who's qualified to serve as a facilitator? What kind of training do they need? In Oregon, they're required to complete only 160 hours of training. 120 of that is part of the core curriculum. It's sort of like classroom learning. And then 40 hours of that is a practicum, a sort of a clinical experience, ideally utilizing real psilocybin at a service center, working with clients, but potentially training programs can utilize other substances or even simulations. But there's a lot of question about whether that's enough training. That's something they're grappling with in Colorado, and I think it's very, very likely that we'll see the training requirements increased. There are other issues like client privacy. Should clients be videotaped during the administration sessions? There have been documented cases of alleged abuse of clients, both in the FDA sanctioned clinical trial setting, or at least I should say government sanctioned clinical trial setting, because one notable case occurred in Canada, and as well as in the underground setting, where there have been allegations of abuse by underground facilitators operating illicitly. So there's a lot of discussion about client safety. And in Oregon, at least under these proposed rules that will be discussed this week, everyone who would be videotaped, the client and the facilitator, would have to give their consent in order to be videotaped. In Colorado, it looks like they're heading in a slightly different direction, where participants or clients might be faced with a choice. They could either have their session videotaped, or they could require an additional person to be present during the session. So these are different kinds of discussions that are being had. And the point that I want to end on, and then I'd like to have a discussion with you, is data collection. So sort of related to the videotaping, but a little bit different. There is a movement to collect as much data as possible from clients in these state-regulated programs. There are a variety of reasons advanced to justify this data collection. One of them is that we might learn something about the safety and efficacy of these substances. Another is that we might gain data that we could take to insurance companies and say, look at this great data. Don't you want to provide coverage for these substances? And then, so there's just sort of interesting scientific experiments one could potentially run and write papers about all this data. But very frequently missing from these conversations are the fact that if you're collecting data from people who are consuming psychedelics, you're collecting data about evidence of a federal crime, that's a federal felony. And in both Oregon and Colorado, that data will not only be stored at the service center, or in Colorado, they're called healing centers. The data will also flow to the regulators, to the state agencies. And when it is at a state agency, that data is very, very accessible to federal law enforcement, which could likely access that data without requiring a warrant of any kind. And so there's been a real lack of discussion of concerns for client safety and confidentiality due to potential data breaches or misuse of that information. Despite all the developments I've mentioned today, psychedelics remain heavily stigmatized, and there are political strategists aiming to enact these laws across the country. They're forging ahead as quickly as possible, and yet there is no protection in these laws, for example, for employees. So if evidence that someone participated in these psilocybin services got out and their employer learned about it, they could be fired. And I think that's a problem when you're setting up a system that is encouraging people to utilize these services, but those protections are not in place. And for comparison, California, by statute, and Massachusetts, through a judicial opinion, provides protection for employees who utilize marijuana, medical marijuana in Massachusetts, and both medical and recreational marijuana, I believe, in California. So that protection exists, and it would be very easy to add it into these psychedelic laws, but that has not been added in. So there are a lot of risks, potential social and legal risks for people that participate in these programs that could harm them, when they apply for life insurance, health insurance, to rent apartments, to apply for jobs. If that data gets out, it could cause problems for people. And I think that this is something that I discussed in an article for Wired magazine last year called something like "Interested in Psychedelics? Check the Data Privacy Clause." But it's a conversation that's not being had nearly as much as I would like. I think the final thing I'll mention is that California really is quickly becoming, Colorado is currently, I'd say, the epicenter of psychedelic legal reform in the US, but California is on the horizon and could be the next epicenter of legal reform. There was a bill, SB 58, that sponsored by California Senator Scott Wiener, that would have decriminalized psychedelics throughout California. And impressively, it passed both sides of the California legislature. So that was really a historic moment, because previously decriminalization had only occurred through ballot initiative at the state level. And Governor Newsom vetoed that decriminalization bill and said that he welcomed a bill next year focused on therapeutic use. So something really modeled likely after Colorado's Natural Medicine Health Act. And so that's kind of the status of psychedelic policy in California. There are 2 ballot initiatives potentially that you might want to look into or be aware of in California for 2024. One of them is collecting signatures now and would both decriminalize and regulate psilocybin, and another has not yet qualified to collect signatures, but that is a very similar bill, but it involves more substances than just psilocybin. So I will end there. This is a really exciting space to watch or get involved with, and things are changing very quickly, and I would welcome your questions or comments. You're muted right now.
Thank you very much. I was sitting here taking notes throughout your presentation. To all of the attendees, you're welcome to put questions in the Q&A place available to you. I'm going to start off with a few questions, if that's okay, Professor Marks. You raised so many issues. I'll just sort of jump around, I think. I had a research assistant look into some issues concerning insurance, actually. Last summer, I was concerned about specifically people who end up in the emergency room with adverse events or believing that they were suffering adverse events, having taken a hallucinogenic substance. And what he found was that insurance companies could, in many, if not most cases, we couldn't survey the entire universe of insurance company clauses on this matter, but could, if they chose, refuse to cover that kind of care because of the intentional ingestion of a Schedule I substance and a substance that carries known risks. And that feeds back into some other kinds of questions too, regarding informed consent, for example. But in this case of insurance, what he found was that we're not seeing a lot of it because medical doctors in emergency rooms appear to be sensitive to this. And so they are not reporting in the documentation in medical files specifically the kinds of information or signaling to people who are reviewing the files that this was the ingestion, the intentional ingestion of an illegal substance. So I think that the insurance question, and I had also come across information about how it was actually difficult in some cases to get insurance for some of the research that was being done. So research facilities, people who were involved in doing that research too were vulnerable because insurers did not want to cover. So I think it's really an important facet that you brought up in this. And do you think that there is any kind of way of looking at the insurance piece as separate from an omnibus kind of legislative approach? So for example, first sort of whittling away at some of the edges of this kind of thing, some kind of focused approach on insurance in specific contexts so that insurers will have less freedom to reject coverage. Is there any possibility, or do we have to wait for rescheduling?
There's also the insurance for the businesses, the service centers and manufacturers. They can have challenges. There are some companies that have expressed interest. There will always be, the odd company that might want to, fill that niche. But it's difficult for me to imagine health insurance companies getting behind funding a Schedule I controlled substance that hasn't been FDA approved. And so looking at it from that perspective, even though there is a lot of evidence for the therapeutic promise and safety of these substances, I just don't know that it's there to entice them to enter this market. Now, there are people in Colorado and Oregon that completely disagree. They think that, hey, if you just show them the numbers, all they care about is numbers. If you can show them that you're extending life or decreasing costs, or that's going to be enough for them. I'm not so sure. I think there's a lot of risk that would come with this. So there are employers. There's a trend where employers are offering, in this case, ketamine, which is illegal. It can be legally prescribed. It's FDA approved and can be prescribed off label. There are some employers that are tinkering with offering that as a benefit. I don't know that would be feasible with the Schedule I substances like psilocybin. So I do think that there has to be FDA approval before we see any substantial serious insurance coverage.
We have a question in the Q&A about, number one, how do researchers go about getting approval to conduct studies with psilocybin? And secondly, the possibility of the use of some of these medications for physical problems such as liver disease, migraines, cancer, those kinds of things.
That's a great question. Researchers have to get permission both from the DEA and from the FDA in order to do this research. And it can be quite complicated and drawn out. That process can take years potentially to get all of the approvals in place. And it can be burdensome. There are a lot of requirements regarding the facilities and how things are stored. And so that does create a certain threshold where maybe only certain institutions are able to implement these requirements effectively and navigate this process. So that is one of the drawbacks of having a substance in Schedule I. It really does inhibit research and create a lot of obstacles. That's been changing a little bit in the past few years. I think the agencies are a little more open to this kind of research. One thing that reflects that is that the DEA is also responsible for setting limits or quotas on the maximum amount of each substance that can be produced. And I mean total nationwide, a certain number of grams, for example. They used to be very, very low. And in the past few years, the DEA has raised those limits significantly, especially this year. I think it was a very significant increase announced. So things are changing and it may become easier, but it's always going to be a barrier being in Schedule I. There are some very interesting potential uses for psychedelics outside of psychiatry. They're primarily related to pain. So things like chronic pain related conditions, migraine headaches, cluster headaches. These are very debilitating conditions. And people have found that taking a small to moderate dose of psilocybin significantly helps them. And there are some trials now that are investigating that. There's some potential uses in neurology. There's speculation. Perhaps they could be helpful in dementia, such as Alzheimer's, because psychedelics do promote neurogenesis, the growth of new neuronal connections. So we don't know if that's the case, but people suspect it could be. I hadn't heard of liver disease, but you never know. I mean, there are, I'd want to see the data. But I wouldn't be surprised. There could be all kinds of physical conditions where psychedelics could be helpful, but we'd have to wait for the research to find out.
We have a question that concerns, the different categories that you are working with in your book and in the presentation. I'm wondering about religious and spiritual uses. So laws that concern those types of practices in which psychedelic usage is part of the religious or spiritual experience.
That's very important. I didn't really mention it in those categories because it's largely been a marginalized issue in these legal reforms that I talked about. Sometimes they will be mentioned. The spiritual religious uses, indigenous uses, traditional uses, they'll be mentioned, but they're usually used rhetorically or to generate support or to acknowledge their use. There's a lot of concern about whether this is just another example of appropriating these substances and the practices from indigenous communities. That in many ways, that is exactly what is occurring. There's some sort of superficial attempts to include these voices in the rulemaking process in Colorado. I haven't really seen yet any significant, really robust ways of efforts to respect those indigenous practices and religious uses. But that's the reason I didn't mention it really in those 5 categories, is that hasn't been a major part of the changes. And when a state legalizes supported adult use or even decriminalizes medical use, is usually at the forefront as the rationale. Medical use for treating addiction or for treating PTSD in veterans. So it should be a bigger part of the conversation. It is a category that needs to be discussed, but it hasn't been as much as it should be.
It it could be unfortunate because these are whole plant substances, and to refer to your talking about Schedule 1 specificity, that we can move synthesized versions or extracted versions, chemical extracts. It's possible that that these will be rescheduled, Schedule 2 or something that will make them accessible, but that the plant from which that synthetic could be derived, that natural use, would remain prohibited under Schedule 1. This leads then into questions that have to do with.
Well, let me say, can I just say one thing about that?
Sure.
I think what you said is really important, because some people may not believe that's a problem, because there is a small number of groups that are excluded from the Controlled Substances Act's prohibition. They can work with the DEA to get access, legal access to peyote, for example, or ayahuasca in some cases for religious use. So some people might think, well, it doesn't really matter if those plants remain in Schedule 1 because those groups have an exception. But in reality, it's a very, very, in most cases, those exceptions are granted. So regarding ayahuasca, for example, through the Religious Freedom Restoration Act, RFRA, so by federal statute. But in practice, it's really only a very small number of groups that have that. It's not a viable means for most religious groups. And so even though I think what happens is a lot of times regulators, legislators, they say, oh, well, the religious groups have that exception. They're fine. Don't worry about them. But really, it's not actually, that protection doesn't really exist for most religious or spiritual consumers of these plants.
I think stated broadly too, it doesn't really cover people who are wanting not necessarily a specific religious experience, but are wanting a spiritual experience. So there's medical uses, there are psychotherapeutic uses, and then there are spiritual uses. And alluding to something that you said about existential angst at the end of life, there are people who want that type of transcendent kind of experience, and it's not really covered by one of the categories yet, correct? So that spirituality and religion writ large seems to be this neglected area, as you say. But leads into another question about commodification and patenting, and I know you've written about patenting. If only the synthesized versions will be acceptable for rescheduling and then being used, then the premium will be placed on the commodification of those and the patenting of those. And so once again, we can see cost increases and more difficulty for some purposes and some people, correct?
Absolutely. One thing I will say about that, so it is primarily synthetic versions that are being researched for FDA approval, but in June, the FDA published draft guidance on psychedelic research, and just earlier this month, my colleague Glenn Cohen, Professor Glenn Cohen of the Petrie Flom Center at Harvard Law School, we published an article in the New England Journal of Medicine called "How Should the FDA Evaluate Psychedelic Medicine?" And one of the points in the FDA's June guidance caught our eye. It signaled the potential for botanical drugs to be approved. So you could conceivably have a plant or fungal-based drug approved by the FDA. But historically, the FDA has pursued that very infrequently, like a handful of times, a very small number of times anyway. So we don't know if that is a signal from the agency that it might be more open to that in the future. But for the most part, yes, it's synthetics that will be approved and rescheduled.
Is the reason for that you can standardize a dose with a synthesized version, and it's very difficult with whole plant versions to really have comparability in the patient populations going through the trials? Is that the reason for it?
I think that is a big reason. And the same issue exists in Oregon, where people are able to consume the whole mushrooms or an extract, a psilocybin extract. It is a lot easier to control the dose with the extract. The mushrooms are notorious for being very inconsistent in how much psilocybin they contain. So I think that is one major reason. There might be others as well, like the naturally occurring cannot be patented. And so if you're going to pursue FDA approval, you as a company may want to create a synthetic version. And maybe one thing that's sometimes done is to do what's called deuteration, where the hydrogen atoms in a molecule are replaced with deuterium. And there's a company called Cybin that has done that with psilocybin. So they have what's called deuterated psilocybin. You can question whether that's really a new invention. Deuteration has been well known in the pharmaceutical industry for quite some time. So is that really a novel innovation worthy of patent protection? That's open to debate, but they are getting patents on these synthetics. But I think that's another reason why synthetics are pursued and more easily to patent. And you can just manipulate them a little bit and patent them.
We have a question that goes to facilitator qualifications and wondering if facilitators would be or should be are required to have had a psychedelic experience themselves.
That's a really good question. That's been discussed in Oregon and Colorado. It's been a contentious issue. There are some people who think that how could someone possibly understand what the client's going through if they haven't experienced it themselves? But there are others who think that would be unfair or unethical to require facilitators to do that. One reason is that it is clearly federally illegal to consume these psychedelics, and people might not want to. Another argument is you don't require the cancer doctor to have cancer or the diabetes doctor to have diabetes. It's kind of a little bit of a double standard. So there are arguments on both sides, but right now, facilitators are not required to have that experience.
I think another point that came to my mind was that if every psychedelic or hallucinogenic experience is unique to the individual, I'm not sure that having had one experience will help a person really connect effectively with somebody who could have a totally different experience, and in fact could cause them to misunderstand what the other person's experience actually is. So I don't know, but it also pushes in the direction of being able to talk to somebody in order to secure informed consent. And I have real questions in my own mind about how is it you can inform somebody about an experience they're unlikely to have recognized themselves as having. And yet in everyday life, I think we pass through altered states of consciousness. And if we can create in people an awareness that they have passed through, that they go into and out of altered states of consciousness on a regular basis, there could be some information that comes to them from their own experience such that they can relate more successfully to what they are experiencing. So we might also see as part of the preparatory period, perhaps ingestion of a lower amount, a non-therapeutic amount, so that people can experience some aspect of it before they would go on a full journey or something like that. Is there talk of that, what the prep period looks like or what informed consent looks like?
That has been discussed, the idea of giving people a lower dose. It hasn't been implemented. They're not required to have a smaller dose in Oregon, for example. Um, I think you raised a really great point about how people can have completely opposite experiences. And so I agree with you, and I haven't really heard that discussed before, that having one experience might not really prepare someone to be any better present and helpful to a client than without it. It could actually mislead them potentially. There's a lot of interest in informed consent. Oregon has a state mandated informed consent document. In the interest of full disclosure, I drafted parts of that, although it's been, edited and distorted since we the committee that I led drafted that language. The whole committee. I imagine that there will be a similar type of standardized form in Colorado as well, but it's a big question. Just to plug another article that our group at Harvard published just this past week in Nature Mental Health about integrating psychedelics into end-of-life care. We talk about the informed consent process and how it could be particularly challenging in people in hospice or palliative care. And we talk about how there is some interest in using things like virtual reality that might be able to simulate altered states of consciousness, at least to give someone some sense of what kind of visual experience they might have. But again, that might not really reflect what they will experience. It's very difficult to predict how any particular person will experience these substances.
I think that at this point, we have covered the context. We have a lot of people who have written in. So perhaps this one I have not touched on. I am a current psychiatric provider and work with ketamine. In your opinion, in what areas of this psychedelic revolution can psychiatric providers most effectively support the efforts of either decriminalization and or legalization of said substances? I recently joined a group in my state that has started the process, and I'm not interested in becoming a lawyer.
I think that's the way that people typically become involved. There are these organizations coalescing around the country. There are a couple different types of organizations. There are what people refer to as psychedelic societies. They tend to have more of an educational focus, where they're trying to form a group that educates people about safe and responsible practices. They usually claim to not actually, help people find psychedelics, but just provide education. And then there are groups that are more focused towards activism and enacting these types of legal reforms. So people who want to get involved in these reforms usually want to look for those groups that they can get connected with, and they often have connections with legislators. For example, in Massachusetts, there's a group called Bay Staters for Natural Medicine that has relationships with Massachusetts lawmakers, and they're looking at a decriminalization bill. In Washington State, there are groups like that. So I think they're everywhere.
Okay, well, I think that we have reached the ending point of our time together. I'm very grateful for your sparing so much time from your busy schedule, and I've learned a lot. I can tell from our questions that our attendees have as well. Thank you.
It's a pleasure. Really, really enjoyed it. Thank you so much.
Thank you. And thank you to all of you who have attended. We will let you know when the recording has been posted, and please look at the UCLA Health Law and Policy Program webpage to see announcements of upcoming speaker events. Thank you, Professor Marks. Thank you, everyone. Bye-bye.